Thanks for joining today. So, as Matt said, we're a London-based law firm. We work almost exclusively within the entertainment industry, and we're probably best known for our music work. And within music, we act for the full range of players from traditional music businesses, so labels, publishers, management companies, to talent, to investors in music rights and companies, to tech and startup companies which interact with music or the music industry in some way, including a number of MTUK members. So we'll each introduce ourselves in a second. Before we go ahead and do that, I just want to emphasize quickly, as Matt said, this isn't meant to be a legal lecture where we hit you over the head with lots of technical jargon. It's meant to be kind of practical and accessible. Our assumption is that most people watching the webinar are either running or working for a relatively early stage music startup or looking into moving into that world. And so what they really want to know is how to set themselves up properly so they can grow and attract investment and all the things that a startup aspires to do in as pain-free way as possible. So what we're going to do is tell you about the sorts of things that we tend to get involved in at the early stage of a startup's life, and then we'll have to take any questions on anything we've highlighted. So moving on to introductions, I'm Alex and I head up Russells' digital and technology team. The work we do is pretty much all focused on entertainment. And what that means in the music context is generally acting for music businesses or talent which are working with technology companies looking at music technology businesses. So my background, and this is a bit of a theme with all three of us, is that I started as a lawyer over a decade ago at a big city firm before I decided I wanted to specialize in music and entertainment industries and work with interesting clients at all different stages in their development, which is something that larger firms tend not to do. So now over to Mark.
Hi, thanks, Alex. I'm Mark. I work in Russell's corporate team. I focus on corporate transactions, including venture capital, private equity investments, buying and selling companies, helping startups, and all kinds of corporate advisory work. Same as Alex, I worked for big European and US law firms in the city for a long time before joining Russell's. And I found that as a corporate lawyer over the years, the most satisfying work I've done has been working alongside clients as they grow through the life cycle of kind of early stage growth, raising money, doing transactions to expand, and then achieving some kind of exit event, which marks the end of one life cycle and the beginning of the next. It's great to be a part of that when that happens. So I'm looking forward to getting to know this group and seeing how we can help. Jamie?
Thanks, Mark. So I'm an associate in the digital and technology team here at Russells, and my practice is similar to Alex's. I work with a range of businesses across the entertainment industry, but with a particular focus on the technology side, helping clients navigate IP, digital and commercial contracting issues in the industry. Much like Alex and Mark, I started my career, albeit slightly more recently, in the city, doing commercial outsourcing and technology work with financial institutions and other large technology businesses, technology heavy businesses, before moving over to Russells to focus more in the music space, which personally is where my passions lie more.
Okay, so we're going to attack this from a few different angles. Mark is going to talk first about corporate matters, and Jamie and I will talk a bit about IP, and then I'll cover off, just for completeness, a few other areas that might be relevant to some of you. But Mark, if you want to start us off with some of the corporate considerations.
Yeah, thanks, Alex. So the idea was that we start to think about, are people legally ready to build a successful company, starting at the time a new company is formed? And what we mean by that really is, are you creating the right foundations, the right beginning for where you want to go? We're going to start with some real basics, because it's always surprising how often these things are missed, which then has the effect of storing up problems for later. So we're going to assume the company already exists, but it hasn't really done much or got very far since it was incorporated. And when we thought about what to highlight, and we're only talking for a few minutes at the beginning of this session, we kind of asked ourselves, what are the things that we get asked the most often by clients? What are the top 2 or 3 things, 3 or 4 things maybe, about new companies that people seem to raise. And the first is, what should I do right now, immediately, to be sure my company is set up right? These are some super basic points, but worth getting them right from the beginning. And the first, really most obvious, is who are the shareholders and who are their shareholdings? What's the split between shareholders? Have the shares been issued in the right way? Have the company's books records been updated to reflect that? Have they got share certificates and so on? I always say to people, these shares could be the most valuable thing they ever own, and hopefully will be. So it's really worth focusing on that very basic paperwork. And we see situations where that hasn't been done, or where things have been agreed or promised but not implemented, and that can store up some real tax and other problems for later. Second thing on this list of what should we do right now would be who are the directors. Company only needs one director from a legal point of view, but often the plan is to create a bigger group of founders or others involved in the business who run things together. But it's important to be clear who is a director and who isn't, and make sure they're properly appointed. The third thing that we get asked about, and this is a really simple one, is where is the registered office? Where's the company's legal address, which might be different from where the business actually is. Often the address that goes on the incorporation form isn't the right place going forward, but people do use that address to send letters. That still happens even in 2024. And we've had situations where important letters addressed to the company don't get found because they're going to the wrong address. So make sure the address on the record at Companies House is somewhere that you can get the post reliably and quickly, when and if there is ever post. Fourth quick thing, open a bank account. There's no obligation to do that immediately, but it's very helpful in achieving a separation between founders' personal affairs and the company's affairs, and the beginnings of keeping a company's financial records. So it's good to address that early on. The next kind of big thing we get asked, perhaps more than anything else, is do we need a shareholders agreement? Should there be a shareholders agreement at the beginning or not? And shareholders agreement tends to be a kind of shorthand for a set of legal documents that cover the relationship between founder shareholders. So that would mean a kind of shareholders agreement, a set of articles of association for the company, maybe employment agreements for the founders, and maybe some basic funding documents for the initial money coming into the company. And whenever there's more than one founder involved, we would say it's best practice, yes, that there should be some kind of shareholders agreement. Leaving aside the kind of legal technicalities and reasons for that, our experience is that going through the process of talking about what the terms of those documents should be as founders, and thinking about some key issues like what's each person's role going to be, what happens if someone leaves, where do their shares go, how much authority does each person have to agree stuff, and what needs everybody to approve it, how many shares should be held back for staff or people in the future, things like that. The process of going through those issues helps the team to kind of form a stronger bond together, get to know each other, and it definitely helps to reduce problems in the future. It does feel a bit like discussing all the worst things that can happen. It's a bit, it's not great when lawyers start asking a brand new company what happens if someone leaves, but by addressing those things, my experience is it actually helps to prevent those things happening. And if they do, people already know how they would be resolved. Without this kind of agreement in a private company, the actual legal remedies that people have are very difficult and expensive to use, and a lot more limited than people think they might be. Having a contract is a lot more helpful. And the third thing we get asked a lot at the beginning is kind of what should we do next? What do we need to do to keep the company healthy, to sort of look after it as it starts to move forward in its corporate life? Just a few things to mention there. So the first thing I'd say is get familiar with Companies House obligations. Everyone deals with Companies House when the company is formed, but it's not a one-off event. There's an obligation to make filings every year, annual statement and accounts and so on, and then to notify certain things the company might do to Companies House. And if that's not done, then the company is in breach of its legal obligations. And worst case scenario, there can be situations where Companies House are entitled to dissolve a company if it hasn't made filings, even if you think it's still trading. Second thing, get on top of record keeping and documenting corporate actions as a company grows, looks to raise money and so on. You'd be amazed how many people ask for copies of things that may have seemed unimportant to begin with, but then become important. So having someone who kind of files and stores documents in an organized way where they can be found in the future and checks things like they've been signed and dated before they get put in the proverbial filing cabinet is very helpful. That would include all kinds of contract the company signs and copies of its corporate records and so on. Third thing would be start to develop a kind of a governance or control structure where the directors meet on a regular basis to review where the company is, look at its finances and what's happening and so on. Doesn't need to be hugely formal, but it should start happening. Directors are responsible for running the company as a legal matter, and having those meetings or moments to pause helps to show that they're discharging their legal obligations. The next thing I'd say is appoint an accountant, possibly a tax advisor. They can often add value very early on by getting systems and thought processes straight in the right way at the beginning. And the last thing I would say is start to develop what you might call legal radar. I'm not going to say appoint lawyers because that's the worst possible cliche to hear from a law firm, but develop a kind of a sense of when is the company doing something that might need to be looked over or might have a legal consequence in the future. Just thinking about whether something needs to be written down in an agreement or thought about from a legal perspective. Again, just pausing to reflect on that for a moment can really pay off and help to head off some problems in the future. So they're just a few quick things or quick thoughts on kind of how to get things straight from the company point of view at the beginning. And now I'll hand it back to Alex, who's going to take us forward with some IPR observations.
Before we do that, actually, Mark, thanks for that. I wondered, we've probably got time for a couple of questions if anyone wanted to leap in now. We'll have a longer session at the end for questions. So if there's nothing that obviously occurs to people at this moment in time, but if there's any questions, please raise your hand. I had one question actually that I wanted to ask. You mentioned about founders potentially falling out at stages in the early stages. I wondered, are there any main things that you've seen founders fall out over?
Yeah, so I think when a company is kind of doing well and creating value and moving forward as planned, that falling out is fairly unlikely. It tends to happen when things go a bit off plan and maybe not go according to what was expected. But the biggest thing I think people fall out over is equity stakes. If that's not clearly agreed up front, then very quickly equity stakes and who owns what and so on is probably the most contentious area, followed by if a person leaves for any reason, what's the deal regarding their shareholding? Do they get to keep those shares? Do they have to give them up? If they give them up, how much do they get paid for them? That kind of what lawyers call lever terms or lever events. If it hasn't been talked through at the start and baked into some documents, as I was saying, that is a tough one to negotiate. Another couple of things, I think pay, how much people get paid. So everyone's financial situation is different, and people need to be a bit transparent about how much they need from a personal point of view and when they need that and so on. Because I think if people are not, and if there's a misunderstanding about amounts of money that everyone thinks they can take out and pay themselves, then that can create some real difficulties. There are other scenarios that perhaps become a bit more of an issue as companies grow, as things develop. And the main couple of things there, I would say, are kind of self-awareness and ability to realize when perhaps someone else needs to be brought in to do a certain role. I think at the beginning, founders tend to do everything because they have to, or sometimes they enjoy doing that. Sometimes they think they're good at things that someone else, an outside investor, might take a different view. So having the ability to see when someone else needs to be brought in, as opposed to founders doing things themselves. And I guess just one, I mean, there are many, but one other one as business grows is some founders feel they need to keep control of their business because it's theirs, they created it. That can create tensions with investors who think there should be others that have a greater say or more control. So kind of control in the broadest sense of that as the business develops. They're some of the main themes. Obviously, there's all kinds of things, but I guess they're the ones we come across more than anything.
Yeah, thank you, Mark. That's really helpful. And I've got a raised hand. I think first of all, we had Katie. Over to you, Katie, for your question.
Sure. This is super helpful. So thank you so much. I wanted to go back to like pay and governance. Sorry.
Yeah.
So I have a board of directors who are helping me build a product for my company.
Yeah.
They're friends. They work in tech companies right now,
Mhm.
and right now everyone is very helpful and very friendly because it's in the beginning stages. What things should I start thinking about to prevent worst case scenario, them asking for a stake in the business or maybe equity or things like that? Because I never even thought about that later on down the line.
Yeah. So I think it's worth having that conversation at a pretty early stage with them. Obviously, you can't do it immediately because you want to get them on board and get them helping and keep it friendly and so on. But as things start to progress, if they're actually making a contribution, a valuable contribution, then I think you do need to have some element of formality around that, even if it's only quite a simple letter, a couple of pages between them and the company that says it's great to have you helping and this is the basis on which you're helping. Because even quite basic things like making sure that what they're doing, the ideas they're creating, belong to the company as opposed to them. This is what Alex is going to talk about this a bit later, but it's worth just being clear that they are helping you in a capacity as an external advisor. The things they do belong to the company. They're not on the board, but you'll discuss that with them in the future. Things like that. Quite a soft letter that feels like it's pretty informal and friendly, but just puts down some sort of markers in a legal sense that it makes it clear that they're doing this for you and your business, and the role that they have at the moment and how that might develop in the future. So there's a couple of things there around who owns the ideas, exactly what their capacity is, that I think it would be worth sort of writing down in a simple way with them.
Perfect. Thank you so much.
I think that's relevant to the question that Marcus has included on the in the comments, which is around the sort of things that investors might want to see that a founder might not have guessed in advance that that's something they'd be asked about later. And Jamie and I are going to come on to this later, but I think in terms of where people are making contributions to the business, especially where they're contributing code, providing some sort of creative input, creating, maybe designing a logo, all that sort of kind of all those sorts of things are things where people often assume that, because they're doing it for the company automatically owns them, or even in a scenario where you've paid them, but you haven't documented those arrangements, that, the payment itself is sufficient to transfer ownership over to the company. And those assumptions aren't correct in the vast majority of cases. So those are the sorts of things that investors often ask about, which is, you say you own this platform, but you weren't the person who created it, or you say you own this logo, but you weren't the person who created it. You had a mate or a contractor who did it. Can I see some evidence that they've given up their rights and given them over to your company?
Yeah. And Alex, just on the question from Marcus in the chat about investor paperwork that might not seem important or might not have been thought of. One thing they might ask for is where a person was working for another company at the time they were developing the ideas for the new business. The investor might say, I want to have a look at your employment contract in your previous job, when you were working on this stuff in the evening or at weekends or whatever, just to make sure there's no language in that old contract that might mean that the old company had some kind of claim on the idea. So yeah, there are some things that investors start to think about really around, as Alex was saying, establishing that nobody else could have a claim on what you're doing, that it genuinely is yours and your company's. Yeah, that stuff doesn't get thought about at the beginning when everyone's keen to work together and get going on a new idea.
think Jamie Palmer had a hand up at one point.
Yeah, hey, thanks everyone for taking the time to come speak to us. It's great so far. Yeah, I was just wondering, in your opinion, is it best or good to set up a company before bringing on co-founders and then adding them on afterwards, you know, for shares investment, etc. And I'm guessing you might come on to vesting shares later, but obviously is setting that kind of thing up easy as well?
Yeah, so on the vesting shares point, we're not going to get that. That's almost like a next level of detail which we can cover in the future. We were not going to get deep into that in this one, but we can cover it in the future. And on the point about forming the company, I think it's fine for one person to form it and then issue shares to the others. Some people prefer to do it together and or the whole group become what lawyers call subscribers to the company when it's first formed. It doesn't really matter. What I would say is that if it's one person that's forming it and not everyone, then bring them in very quickly afterwards. Don't kind of say, well, I'll form it, and then one day we'll get round to bringing the others in. We've seen that happen, and yeah, that can cause a whole load of difficulty sometimes from a tax point of view if the company increases in value quite quickly, and also just from a point of view of making sure everyone's happy and knows they have their place in the company. There's a bit of important symbolism around saying we are shareholders, these are our share certificates, we all own this business. It's an important moment to recognize when you've done that. So if one person forms it, I would say do the paperwork for the others to come in ASAP after that.
That's great. Thanks, Mark.
Thank you. I think we've got one other question from Katie, but I think I'd suggest perhaps we move forward with Alex's section of this, and then we can come back to lots of questions at the end of the workshop. So maybe over to you now, Alex.
Yeah, I mean, I touched on this slightly, Katie, in my section, so we can definitely return to it after that. But yeah, so I'll just do a little bit on IP now. So I think I'm conscious that the MTUK membership is a broad church. Music startup doesn't mean any one thing. It doesn't mean that they're solving any single problem in the music industry. You know, they might be a lot of the conversation or legal conversation around music startups tend to be quite sort of licensing focused and assume that all startups are looking to go to Universal Music or whoever to license their catalog. That'll be true for many startups, but it's certainly not true for everyone. And so we will touch on music licensing in our second webinar, but we thought it'd be useful to sort of cover some commonalities that we see across kind of all music startups, you know, whether they're using music rights or not. In our experience, some of those are things like, you know, what do most music tech companies tend to be doing at an early stage? They tend to be developing software. They want to commercialize that and protect it. They'll have a name, obviously. They might have some sort of branding, logos, other sort of designs that they use in association with the company and its marketing. They want to make sure that no one else has already used that name or logo. They want to make sure no one starts to do that in the future. They might have an innovative idea, you would hope, which, you know, they have a problem they want to solve and they're hoping that no one else has thought of it. But that can put you as a startup in a bit of a kind of catch-22 situation, which we see a lot, which is that on the one hand, you don't want to let the cat out of the bag and tip other people off onto your idea. On the other hand, if you never tell anyone about your idea, how are you ever going to get customers? How are you ever going to get investment? How are you ever going to get off the ground? So that's something we're kind of used to dealing with. And then what Katie's just touched on and a few other people have mentioned already, which is the sort of the day job thing. So, you know, you're working on the startup, you know, in your evening or in your weekends, or, you know, you might even be doing it at your work computer. Is that okay? Is that a problem? That presents some practical and legal challenges. So in terms of how we tend to get involved in those kind of practical questions as lawyers, there's a sort of, you know, explaining to people how IP works at a sort of fundamental kind of high level. So there are different types of IP rights, and it helps to understand that. So, you know, if you have an invention, you might be looking at patents. If you have branding or a name that you're looking to protect, you might be looking at trademarks. If you have creative work of some sort, so written work or text or videos, audio, that sort of thing, that is protected by copyright. But importantly also, and it wouldn't seem, it's not obvious, software is treated for copyright purposes as what's known as a literary work. So it's protected in the same way as a novel or a screenplay or something written. That's quite important to be aware of. So patents, trademark, copyright, those are the sort of three most important areas of IP, but certainly not the only ones. And even those all work in slightly different ways. So firstly, all of those rights are territorial, so things are very different from country to country in terms of how they work. And even within the UK, some of those rights need to be registered. You need to take active steps to make sure you get that protection. Some, like copyright, arise automatically. You don't necessarily need to take any step other than just writing it down and recording it somewhere. They all have different terms in terms of length of protection. Some can be extended indefinitely. Some have a kind of a maximum time period that you can be protected for. There are different policy reasons behind all of that we probably don't need to get into here. But so that sort of aerial view of what IP is and what it tends to kind of cover is helpful. Equally, it's helpful to let people know, clients know, what IP can't do for them. So there are limitations on what IP can protect. And so to go back to the idea, you've got a great idea thing. You might have a fantastic idea or concept, and you might be thinking, is there some way I can get a monopoly on this? I can stop other people from using my idea, or if I tell people and they use it, and I can go after them. And unfortunately, there's no IP right that would do that would give you a right against the sort of world at large to stop you, to allow you to stop them copying your idea, if it is only an idea at that point. What you can do in that situation is restrict access to the idea to a small pool of people. That's a practical measure. And then a legal measure is to then get those people in that small group to all sign NDAs. But the important thing, and the NDA might say that person won't disclose the idea to any third parties, and they'll only use it for very restricted purposes. But that only works against the people that you get to sign the NDAs. So where that's different from an IP right is this: if you have a copyright work, or if you have a patent or a trademark, and some total stranger uses that, without your permission, then you can go after them, even if you don't have a sort of direct contractual relationship. So a few other things that we tend to speak to clients about in an early stage, helping people understand if what they're planning to do infringes on other people's rights. So the music licensing piece is part of that. But equally, there are fundamental things like checking that your proposed name isn't already registered as a trademark by someone else in any of the territories where you might want to operate. And there's a sort of certain types of analysis that you need to do there, because even in a scenario where your name isn't identical to someone else's, trademark law might still bite. Helping people understand how the day job might impact their startup, we've talked about already. And Mark was talking about your employment contract that your investor might ask for at a later stage. What did you say was going to be the treatment of any work you do in a particular industry or area? Did you technically sign up to just work for that company? Have you agreed restrictions on what you can do with information you learn as part of your day job? There are various provisions in an employment contract that might be relevant. And then the other thing we do a lot of is helping people with all of their IP related contracts. So at an early stage, that's generally going to be focused on creating IP or acquiring it or licensing it in. It's going to be focused on building up an asset base. But you might at different points also be licensing out IP, and that's the sort of thing we can also often advise on. So I think Jamie's now going to cover IP in a bit more detail, and we'll touch on some of the points around getting contractors involved and that sort of thing.
Do we have any brief questions? Maybe one or two questions before Jordan's leapt in there with a question straight away for Alex.
Hi, good day. I have a question concerning the use of AI in music. The developing use of AI in music. So if you have a band with several people, different voices, maybe there's a lead singer and other people who sing in the music. Uh, I know some AI companies now are looking at musicians, probably not the most popular musicians, but some of them, to license out their voices to them, to then use as part of their AI, where other people can use the singer's voice to create music on their own. And if you have a band that has several singers, you probably don't want your band to have you don't want a singer from your band to have their voice out in other musical work. So I'm just looking at the practicality of sort of like the individual right versus the band, the right to the band or the company, right? To own that person's voice or keep that person's voice exclusive to the band, and also how it impacts on the branding of the band.
So we've been asked a lot of AI music questions over the last couple of years, and actually that's a new one. So can you, if you're in a band and if you're in, the Rolling Stones and Mick Jagger goes off and licenses his voice to some AI company, can you stop him? That's an interesting one. I mean, in my example, Mick Jagger's voice is Mick Jagger's voice. It would be quite unusual for, and we're sort of drifting now into kind of arrangements with musicians rather than startups. So it's a rabbit hole I don't want to go too far down, but generally kind of band partnership agreements wouldn't sort of pool ownership of the singer's voice, for example, so because when you break up and you go off and do your Mick Jagger solo album, the other members of the band don't have any sort of control over that, and in a sense, licensing voice is a different application of the same issue, really. Is people using their own personal characteristics to create some other creative output. It might traditionally have been a solo album. These days, it might be licensing your voice for use for a startup. But no, I mean, could you use some very creative legal arguments, perhaps, to if there was some suggestion of passing off? So I don't know if collectively as a band you could rely on, so that there, as well as registered trademark rights, we have unregistered trademarks. So passing off, which in this world effectively means false endorsement. Could a band give some thought, or the rest of the band members give some thought to whether actually, if the Rolling Stones bot started creating music, and Mick Jagger had licensed his voice and the others weren't into it, generally their remedies would be in things like if the actual band name was used, which would be a collective collectively owned piece of IP, might be registered as a trademark. If there was some, even if the person wasn't using the name, but they were creating very, very strong kind of association with the band through other sort of nods and winks, passing off might be a kind of an answer to that. And passing off is something generally which we're looking at quite a lot in the context of performers trying to do or trying to exert some level of control over their use of their voice and their face and their likeness in AI. Normally we're talking about it in the context of where the Scarlett Johansson type case, where somebody's having their voice or their likeness used without their permission. But the question you ask about where one person gives permission but the rest of the band don't like the idea of it is an interesting one. But I think in practice it's going to be quite hard for the other band members to police that.
That's great. Thank you for that, Alex. Let's move forward to Jamie's focus now, and then, as I say, we'll have plenty of time for questions after that. Thank you.
Great, thanks, Matt. So, as I'm sure you've all picked up on by now, IP is pretty core to any technology business, and as you're getting started, we always find it important to work out what IP you currently have and what IP you're going to need going forward, whether that's IP you'll develop yourself or IP you're licensing or use contractors for. One exercise we recommend doing at the early stage is conducting a mapping exercise of your IP, which can be immensely valuable to help you visualize both a long-term IP strategy for your business and to enable you to identify and remedy any deficiencies you may have at that early stage. As part of this exercise, one thing that's quite key and that was briefly discussed earlier relates to actually who owns the IP in a business. There's often some confusion as to who owns IP when in the early stages you use contractors to help develop IP. So for instance, if you've got a tech platform and use software, if you've used a developer to help generate code for you, generally in those cases, the IP would still be owned by the contractor unless they've entered into an assignment or an arrangement to grant the ownership of those rights to the company. One thing we've actually seen countless times, particularly when we come to the sale of the company, is a company has at its early stages employed a contractor to develop IP for them. They've done it quite informally and haven't done any contracts around the creation of that IP. Then 5-10 years down the line, when it comes to the sale, the buyer is asking for proof of ownership of that IP, and they have to scramble around, find the original contractor and try and get some paperwork in place with them to ensure that they are granted the rights in that. The position for employees, if you have them, rather than contracts, is slightly different, but it's still important to get agreements in place with employees dealing with IP rights, and this can actually be incorporated into the employment agreement you have with those employees. Equally, if you develop IP yourselves, you can't just assume that because you're a shareholder or a director of the company that the IP you create automatically invests in the company. This is traditionally an issue we see when someone creates IP, be it that a brand, a platform, or something more thorough, before the company is incorporated, as the company won't own the rights in that IP unless the founder has actually granted such rights to the company. And again, we'd usually expect paperwork in place just to document this. So going back to using contractors and suppliers, there are various things to consider when using third parties to create technology products. Now, I'll briefly touch on that in a moment. But on the IP side in particular, one point to ensure when your company's being granted rights from a third party is that those rights come unencumbered, i.e. that when you're receiving rights from a contractor or a third party, that you've not got any additional obligations or burdens on the IP you're being given, because this can often undermine the amount you're paying them for that service. Where this gets complicated in particular is when you're using developers to produce code for you. Those familiar with the software coding space may have heard of outsourcing open source, and copyleft software. Open source software is effectively code that you can use freely, and you can get that on repositories online. But certain bits of certain pieces of code that you find online are often under copyleft licenses, which is the opposite of copyright. If you take this code and amend it, you then have to share that amended code publicly online and allow people to use that code freely. Obviously, this can be a bit of an issue if you develop something super valuable in a bit of code, if you then have to share that online, as it could undermine something critical to your business. We typically expect contractual protections with your developer or contractor to protect you against that. On the point of contracts, and again, Alex touched on this briefly earlier, we spend a lot of our time helping kind of music tech startups arrange contracts with suppliers, contractors, third parties, and it's certainly a topic we could spend all day on. but just in the short time, I would advise that the kind of three things you want to think about when entering into kind of tech agreements with third parties are what you're looking to purchase, when do you want to receive that by, and what price you're paying for it. If you can get these three things kind of nailed down and crystal clear, then it's going to make the rest of the agreement much smoother, and your process dealing with that third party much more smooth. Similarly, we'd always recommend when dealing with tech, software, digital type arrangements, particularly having in place measures to test that what you're receiving fulfills the requirements that you have and meets the expectations you have on that. So especially as dealing with anything in the tech space can often be prone to defects and errors. And this is something that you want to kind of future-proof in your contracting arrangement so that you're not receiving anything that could be slightly dodgy or not fit for the purpose you intend. So that was a bit of a broad overview of the tech and IP area, and I'm happy to take some questions on this, or we can hand back to Alex, who's going to talk a bit more broadly about some other common areas that we help music tech startups with.
We could go back and answer Katie's question as well, if you're still interested in knowing that one, Katie. Shall I jump in while people think if they've got any other questions?
Yeah, sure, Alex.
I think I was just thinking about this as Jamie was talking, and I think with the sort of employment, how do you show that your employment was unrelated to your new startup? I think there's the difficulty often with giving these sort of answers in these sort of sessions is a lot of stuff comes down to what pieces of paper have you signed in the past. So, any analysis would need to start with the specific employment contract that you signed with your old employer. But I think if we can sort of put it in two buckets, so two sort of things that you'd need to think about or investigate here. So the first is around kind of ownership of rights. And then the second is around kind of contractual restrictions you might have signed up to in your contract. So around ownership of rights. So the first thing is just to go back to my point about how IP doesn't protect ideas in and of themselves. So if you sat at work and you had a great idea, but all it was, wouldn't it be great to have a, blockchain startup that did X, Y, Z, then, your old employer wouldn't have any claim to that. If you were doing something more specific, like writing code during the period of your employment, then it would come down to a bit of a combination of what you've signed in your contract plus what the law would say ordinarily. So if there was no employment contract and no IP clause in your employment contract, you'd fall back on what the law says. And the law really revolves around whether you're doing something in the course of your employment. And that can be quite a difficult set of questions to look at, and it would very, to give you proper advice on this, we'd need to sort of ask you a load of questions about, well, what equipment did you use, when were you doing it, how similar is what you were doing to what you were doing in your day job, but is there some delineation between what you were doing in the job and what you're doing in the startup? So that tends to be what it kind of comes down to. You might have signed an employment contract that has slightly more kind of aggressive IP terms, and in that case, it would really just be a case of looking at what that clause said. And then on the contractual restrictions point, a couple of things to think about. So usually employment contracts would they might say that you are only meant to be working for the company. Or they might normally have some sort of post-term restrictive covenants. So they might say that for a period of time after you leave the company, you can't, compete with the business, or you can't, approach or engage with customers or suppliers or employees. So those are other areas where people tend to sometimes fall foul of their employment contracts because, they managed to keep a clean separation between what they were doing at night and what they're doing in the day job, but then they went and tried to hire, the entire dev team or whatever. And then the other area is where people sign up to contractual restrictions you need to think about is confidentiality clauses. So there might be some clauses in the employment contract that restrict what you can do with things that you learn in the course of your employment, or information you come across. And so even where something's not IP protected, if you get to know certain things about the business and then you reapply that knowledge, that would be something where you might need to think about whether that falls foul of the confidentiality provisions. Those are all very kind of strictly legal considerations. In practice, people often do things that cut across their employment contracts, and they've engineered a departure that's on good enough terms, and where everyone sort of understood that they were going off to do something else, and they were broadly okay with it, where these things aren't going to come back and be a problem. But if that is something you're concerned about, specifically in your or someone else's case, then it's always worth having a look at the employment contract, some of the questions that I've been talking about.
Thank you. I think it's maybe.
That's great. Thank you. If that's kind of all of the main kind of content from Russell's throw, should we move over to questions now, guys? Is there anything else that anyone would like to raise a hand on, and we can take any questions? Oh, yeah, over to you, Katie. Yeah.
I was just saying thank you so much for the advice. I may have to speak with you about jurisdiction, because I was both.
Sorry, Katie, you're quite faint. Are you able to move a bit closer to the microphone, because I can't hear you?
You there, Katie? Oh, she's going to message in the chat.
In the chat, yeah.
Yeah.
Okay.
Got a question from Marcus here. Maybe we just take that one first. So could you give us an idea of pricing for startups? Does it differ from full rate for corporate clients?
Shall I answer that, Mark?
Yep.
So I sort of alluded to this when I said at the start that that all of us left big city firms to come and work for a firm like ours. Big law firms, have cost bases that mean that they have to kind of get you on the clock from day one. And what we're used to dealing with, across all of our clients, is kind of riding with people on the journey. So we are fee sensitive, sensitive to people's fee sensitivity. And we understand that people, if you clobber somebody with a big bill on day one, it doesn't help them get going. So, whilst like other law firms, we, in theory, have sort of hourly rates, what we tend to do is have a sensible conversation with somebody on day one about what their legal budget is, what they can realistically afford to prioritize, because sometimes it's a case of working out, do you really need to do this or not? And then it's a question of what's the most cost-effective way to do it, and then and then we can find ways to work with people. So working on rates might be good, but equally sometimes people want to have a sort of fixed fee. We can have those sort of conversations, and sometimes where appropriate, if it's very clear that somebody's on a trajectory somewhere, we can also work out ways to build them at an appropriate time when the money comes in. So, for example, when we do kind of big sales, we're not billing people before they get the check, on completion of the deal. We generally kind of we work with them, and we wait to bill them until they're in a position where they've got money in their pockets and they can afford to pay the fees. Don't know if you want to add anything, Mark.
Yeah, no, I agree with all that. I think the other thing I'd say is that we're not lawyers that charge from sort of minute one. We're very happy to meet up, talk about things, figure out what needs doing, and give some kind of initial feedback. That doesn't cost anything. And then as part of that process of talking and getting to know you, we'll figure out what the work looks like and what we would charge for it and when and so on. As Alex was saying, it isn't a case of the kind of the famous lawyer's fee clock starts running from minute one. It doesn't. We spend a bit of time getting to know you first and working out what's the best way to work together.
I think that's important, because I think people have a right to meet a lawyer and decide if they want to work with them or not. They shouldn't have to be paying for that initial meeting. I feel anyway. So.
And I've just dropped our contact details in the chat, just in case any of those queries we wanted to pick up separately with us.
Yeah, that's great. Do we have any final questions? Sorry to jump in, Mark, over to you.
No, I was just going to say, if anyone has any ideas for next time, because we're doing a couple more of these sessions, then please send them through, and we can think about how to build that stuff into the future sessions.
Any other final questions before we close? Any raised hands on anything we've discussed on today's session?
Hello, can you hear me? I have a question.
Hi, Nat.
Yeah.
Hey, I'm actually on my honeymoon right now, but I couldn't dare resist joining this call, so I am driving, so the connection could be terrible. What kind of amount of shares, or range of shares do you see in music tech startups in the UK at the moment?
What do you mean by what kind of amount of share? What do you think? If you just give a bit more context as to what you're thinking of.
So, because you're talking about shareholders, how much people own of a company. As far as I'm aware of, that's done either in some type of percentage agreement or by setting an amount of shares for that company. And is there a norm in the industry of how to set that divide? You were talking about saving stuff for future stuff, or it could be artists that work with the company, etc. What are there any norms within dividing that up?
Yeah, so I think well, the short answer is it varies a lot. So obviously, when the company is formed at the beginning, the founders own 100% of it. They own all of it, and the split between the founders tends to vary based on what contributions are they bringing at the start. Sometimes there's one guy that's a lot more experienced, that had the idea and might be kind of bringing the bulk of the value to begin with, and the others are sort of brought on board to manage and work together and help and so on, in which case you get a much bigger shareholding for the one that's contributing the most value. So that the split at the very beginning tends to depend on what value people are contributing. Then kind of next step, how do we bring in other staff and other people that are working with us? I mean, the ballpark norm for allocations to sort of staff option programs or equity awards tends to be broadly 10%, 15%. In some tech companies in the US, it might go up to 20. In the UK, it's probably nearer to 10. That's a sort of norm. As regards the other point you raised about artists that might invest and so on, I don't think there's really a norm or a number around that. It depends on what they're bringing, the value of what the contribution might be in a kind of soft sense. Once you get onto dealing with investors and so on, it's much more about what's the valuation and how much are they investing. It becomes a lot more scientific. But before that, it's a much more kind of soft, what do I think this contribution's worth to the company, and how much do I want this person on board? But the thing that I always bear in mind, that's been said to me by a lot of successful venture capital investors, is that they say cash is cheaper than equity. In other words, equity is the most valuable thing you can possibly have because of its potential for growth and what it can deliver in the future. So where possible, I think sometimes as a founder, it's tempting to think, well, I'll give a bit of equity there, a bit there. There's a way of bringing people on board. It sometimes pays to be mean about that and give as little as possible, just because of the sort of value effects in the future of keeping as much as you can for yourselves, for the founder group. So it's quite hard to give sort of broad general themes on that, but you're very, very happy to have a conversation offline about what some specifics might look like.
Thank you very much for that answer.
Thank you. And I think actually, thanks for that, Nat. And I think actually looking at the clock, we're out of time now in terms of today's session. I just wanted to say a big thank you to Russells for taking all of these questions and talking us through all of this fascinating stuff. Hopefully it's been really helpful and practical to everyone on the call. I've certainly learned a thing or two. So yeah, so thank you guys. Thank you to Mark, Alex and Jamie. I had to say just we've got a second session coming up from Russells on the 17th of October at the same time as this 1 p.m. So I hope to see you all there. And yeah, thank you for joining. Speak to you all soon. Bye bye.